Start.
The topic for this morning's pre-bar review, which will also serve as pre-mandatory legal education on commercial law. The third subject in the bar examinations, and so far the biggest coverage in all the subjects. So we have the old Code of Commerce of 1889, Spanish Code of Commerce of 1889, which is still good law up to now, despite the amendments to many commercial laws involved, such as law on transportation, but some portions of the Spanish Code of Commerce are still in effect with respect to maritime commerce. The provisions on inter-island shipping is still governed by the old Code of Commerce, although it has been superseded, or rather amended, by the Civil Code provisions on common carrier. Now, the general provisions of the old Code of Commerce are still in effect with respect to transactions that are still governed by the Code of Commerce. And what are these? These are, as I have mentioned, maritime commerce, and then joint accounts or cuentas in participation. Now, insurance has been amended, taken away by the insurance code. Still under the Code of Commerce are letters of credit, and the corresponding mandatory adjunct law is the trust receipt law. The important thing to know is with respect to contracts that are still governed by the Code of Commerce, and among them also are charter party. There was a joke when a student was not prepared in transportation, and our professor in UP, Maria Clara Lopez Campos, asked a question to a student who did not study, and the question is, what is a charter party? And so it has something to do related with a boat. And the student who did not read the Code of Commerce said, "Ma'am, it is a big party held in the boat." So everybody was laughing because a charter party is a contract to lease a boat, and there is a distinction between a bareboat charter and a demise charter, or charter of the entire boat, including the crew and everybody else, because the distinction is important with respect to the liability of a common carrier, where negligence is presumed in case of injury to passenger or damage to the cargo. So if it is a bareboat charter or lease of a boat, the owner remains liable as a common carrier, who is liable or presumed liable in case of injury or damage, injury to passengers or damage to property. On the other hand, a demis or a charter of the entire vessel, including the crew, the charterer or the lessee pro hac vice, meaning only for the particular voyage, would be considered as a common carrier and would be liable for injury to passengers and damage to goods. The liability is presumed. Now, we will go back to transportation. I am just explaining what contracts are still governed by the Code of Commerce. The policy or the intent of the Code of Commerce is that time is always of the essence. So in case of perfection of a contract done through correspondence, under the Code of Commerce, where time is always of the essence, the contract governed by the Code of Commerce is perfected when the offer, again I repeat, this is with relation to contract perfected by offer by mail, where the offer reaches the offeree, the contract is perfected automatically under the Code of Commerce. Now, if the contract is governed by the Civil Code, that is not governed by the Code of Commerce, then the Civil Code provision would apply. There will be a perfected contract when there is a meeting of the minds between the parties on the subject matter and on the prestation or consideration. So until there is a meeting of the minds, the contract is not perfected. Now, there are ramifications and integration and correlation that we should make, because some contracts are perfected by delivery, and where the perfection of the contract is by mere delivery, there is a distinction of a contract that is perfected by delivery, like a promissory note or a bill of exchange. A negotiable instrument is a real contract which is perfected by delivery. Without delivery, the contract is not perfected. That's why there is a question usually asked in the classroom. An instrument that is negotiable, compliant with all the requisites of negotiability, but printed on a wall, is that a valid negotiable instrument? And the answer is, it cannot be delivered, so how can it be valid? It cannot be perfected because it cannot be delivered. But with the advent of modern communication, this might not be much of a problem, because the email is easily accessible to the offeree. But the trouble is, if the offeree has not opened his email and has not seen the offer or the acceptance of the offer, there will be a problem, because there is no meeting of the minds. There should be a confirmation. But under the old Code of Commerce, Spanish Code of Commerce of 1889, time is always of the essence. And while I am here, so I will not forget, in the law on contract, without default, there is no delay. One exception is if time is of the essence in the transaction. And number two, when it is so stipulated and that there will be default upon coming of a particular date, even without demand. But the general rule is without demand, there is no default, except when time is of the essence in the transaction. And number two, it is so stipulated. And number three, there is no need for a demand if in the meantime the obligor has become bankrupt. So there will be default. Now, without default, no interest is due. And interest to be valid must be stipulated in writing. And where the stipulated interest is potestative, as in floating rate, where the bank is imposing floating rate of interest without the consent of the borrower, then the interest rate is null and void because it violates the essential equality between the contracting parties. Now, while I am at it, so by way of correlation, what are the general principles of a contract? An important principle which is not provided in the Civil Code is the principle of complementarity of contracts. Everybody is aware, and any bar reviewee, I suppose, would know the principle of relativity of contract, that contracts take effect only between the parties, except stipulation for Arturo, where a favorable clause is inserted by the parties in a contract, and the stipulation for Arturo is accepted by the third party. So that is the principle of relativity. Now, the principle of complementarity is developed by case law or jurisprudence. That is, where there is a mother contract and there are implementing contracts that are to be executed in order to effectuate or implement the mother agreement, usually known as MOA, Memorandum of Agreement. Now, what I suggest in my practice, the implementing agreement should already be attached as annex to the Memorandum of Agreement, so there will be no problem. Under the principle of complementarity in the law on contract as established by jurisprudence, the implementing agreement cannot vary or alter the tenor of the principal contract or the mother contract. That is simply the meaning of that. Now, what are the obligations in an ordinary contract? We will go back to commercial law. But anyway, this is I think part of also commercial law, because the law on contracts under the Civil Code have supplementary application to the Code of Commerce, even though the contract, for example, trust receipt, implementing letters of credit, still, while these are governed by the Spanish Code of Commerce of 1889, the provisions of the Civil Code, as enacted in 1950 by the Code Commission, still apply suppletorily, meaning that in the absence of specific provisions in the Code of Commerce, then the Civil Code will apply suppletorily. Now let us again, the principle of essential equality in between the parties as a requisite for a valid contract, going back to the floating rate, where the floating rate fixes the right of the bank to change the interest rate either up or down based on market forces, that is a valid stipulation or agreement. Now, where the bank is imposing a potestative rate, meaning not based on the market forces, but let us say based on overhead expenses and the policies laid down by the credit committee, that is potestative without the written approval of the borrower. And in that case, where there is a written agreement to pay interest and the stipulated interest rate is null and void for being potestative, then we apply the legal rate. And I repeat, the legal rate since July 1, 2012. In the case of Bayani Andal versus PNB, as laid down by the Monetary Board of the BSP and affirmed by the Supreme Court in that case of Andal versus PNB, the legal rate is 12% per annum or 1.5% or 0.5 per month. That's the legal rate of interest. Starting July 1, 2012. And that has been followed by all the other decisions of the Supreme Court. You might be wondering, how come that the central bank has amended the usury law on interest ceiling, which is an act of Congress, in the guise of regulation? The power to regulate can only implement and can only effectuate the policy laid down by Congress. I have been raising that in most of my cases involving interest rate, but that is the ruling as of now. Now, going back to the old Code of Commerce, I am wondering why under the Code of Commerce, the syllabus of the Supreme Court in every bar examination would include the bulk sales law, the warehouse receipt law, and Presidential Decree 115. It's okay. The trust receipt is germane or belongs to the heading letters of credit under the Code of Commerce, because a trust receipt is a security in a letter of credit transaction. Now, what is a letter of credit? It is an order to a specific person, by definition of the Code of Commerce, to pay money. And this is usually resorted to an importer or even a local buyer who wants to buy supply or goods, will go to the bank and open a letter of credit. There is if the importer has the money, then the importer will deposit the money for the amount of the letter of credit that will be sent to the supplier so that the supplier will arrange to deliver the goods ordered by the importer. It does not have to be importation. It might be a local transaction. If the bank will lend money because the importer does not have sufficient capital, if there is collateral, well and good. If there is partial deposit, well and good. But if it is a total credit transaction, the trust receipt will come in, because under the trust receipt, the goods will be paid by the bank to the seller. The seller will send the goods to the importer. Now, the importer, under a trust receipt agreement among the importer, the bank, and really between the importer and the bank, the bank will issue, the bank will require a trust receipt, which is a security, under an arrangement whereby the goods will be allowed by the bank as creditor to be delivered to the importer, and the importer is authorized to sell on the same condition as in the case of estafa by trust and confidence, that is the importer is called the entrustee. The bank is the entrustor, and the arrangement is that upon sale of the goods, the importer or entrustor will pay the bank the loan. So that is a credit transaction under the trust receipt. Now, in case of default, that the bank, or rather the entrustee or the importer, is able to sell the property and yet fails to remit or pay the loan to the bank, then the importer will be guilty of a crime as in estafa, through misappropriation by abuse of confidence under Article 315, first paragraph. And that is similar to entrusting a jewelry to be sold on commission, and if unsold, to return, and if sold, to pay the agreed price. That is the same concept of the relationship between a trust receipt and a letter of credit. Now, under the Code of Commerce, a trust receipt, a letter of credit is defined as an order to a specific person to pay some certain in money. Is it negotiable? If you follow the definition in the Code of Commerce, it is not, because the amount, some certain in money, is payable to a specific person. But if you go to a bank, you apply for a letter of credit, you will see it is negotiable in modern practice. All the banks have negotiable letters of credit, because the function of a negotiable instrument is to serve as substitute for money. So it is it should be negotiable. But anyway, if it is not negotiable in form, it might be assigned. But the trouble is the benefit of a negotiable instrument is that it vests good title to a holder in due course, regardless of what has happened in the prior transactions. That is the problem. If you are asked in the bar, you can say, by definition of the Code of Commerce, a bill of lading is not negotiable because it is payable to a specific person, by definition, under the Code of Commerce. However, in modern practice, all banks issue letters of credit payable to a specific party or bank or order. So it is negotiable because it complies with all the requisites of negotiability. Now, I will not repeat when I go to negotiable instrument the elements of negotiability. Most of the problems given in the bar every now and then is whether a particular instrument is negotiable or not. So you test the negotiability by going through the elements of negotiability. But then there are exceptions, and do not be misled by the exception. One requirement is that it must be payable in some certain in money. A certain money is not some certain, but it must contain an unconditional promise or order to pay a sum certain in money. Now, if it is not to pay a sum certain in money, but to deliver goods, then that is covered by the negotiable document of title, the warehouse receipt law, and the provisions of the Civil Code in Book 5, Special Contracts, on negotiable document of title. However, by way of an exception, even if the prestation is to pay in kind, let us say pay to X or bearer 1,000 pesos or 1 sack of rice, that is not negotiable. Now, because to be an exception, the option to receive the payment in kind should belong to the transferee or the holder. Otherwise, it would not be negotiable. So, if the option belongs to the drawer, it is not negotiable. So, look at the exceptions or ramifications of each and every element of negotiability. We have discussed it already. Now, I think that we have also discussed the rule on forgery. Just remember, where a signature is forged, all parties prior to the signature are prior to the signatory are released or discharged. That is the effect of forgery. However, there is a requirement of notice of dishonor to prior parties. In case notice of dishonor to parties liable, and that refers to a person who negotiated after the forgery. They are liable for their warranties by reason of their endorsement. And there is a distinction between a negotiable instrument that is payable to bearer and might be negotiated by mere delivery. the person negotiating by mere delivery is not liable for the insolvency of the drawer. However, a person negotiating by endorsement is liable because of his warranty as a general endorser, that he warrants the capacity to pay and the genuineness and due execution of the document. Now, we have discussed before between the drawer and the drawee bank. The drawee bank, in case of forgery of the signature of the drawer, the drawee bank will bear the loss because the proximate cause is the negligence of the bank for not detecting the forgery, because the bank has a signature card and is supposed to know the signature of the drawer. The first four requisites of Section 1 of the Negotiable Instruments Law refer to promissory notes, where the fifth requisite, it must be addressed to a drawee with reasonable certainty. If the drawee cannot be identified, the instrument is still negotiable and valid, but may be treated as a promissory note where there is no drawee and the drawer becomes the maker. Under the Code of Commerce, you have letter of credit. What is the definition of a letter of credit? An instrument issued by a bank on behalf of one of its customers, authorizing an individual or a firm to draw drafts on the bank or one of its correspondents for each account under certain conditions of the credit. So, a letter of credit is a credit granted to a buyer or an importer. Now, there is a very important decision of the Supreme Court on the nature of a trust receipt. A contractor borrowed money from the bank under a trust receipt security arrangement, and the contractor got the building materials and incorporated them in the building that he erected. The bank now sued for non-payment because the contractor defaulted. How can the contractor return if unsold? Because it is a security arrangement whereby the entrustee is allowed to take possession and to sell, and if sold, to remit the payment of the loan, or if unsold, to return the commodity unsold. In other words, the bank has a right of repossession, and that is exercised by the bank in case of default, but that cannot be exercised. So the Supreme Court held that is an improper trust receipt agreement, because the building materials incorporated in the building may no longer be repossessed by the bank. And important principle in letter of credit, and I suppose this might be asked, this has not been asked in a long time, is the independence principle in letter of credit. So let us say that Metrobank sends a letter of credit to finance the importation of building materials from the U.S. The correspondent bank in the U.S. will notify the supplier that there is a letter of credit opened for him for a particular importation. So the supplier will now arrange to send it, and what is involved is a bill of lading. But we will come to that when we go to transportation. Under the independence principle, the correspondent bank does not have the responsibility to ascertain the quality of the products that are imported under a letter of credit. They are only concerned with the regularity of the documents involved. They do not warrant, the correspondent bank does not even have to look into the quality or investigate the quality of the goods transported. What if there is fraud? There is fraud by the exporter. Under the independence principle, as long as the notifying bank is not involved in the commission of the fraud, the notifying bank under the independence principle is not liable. It is liable only where it is a participant in the fraud. So that's the independence principle in letter of credit, with the only exception that the principle will not apply and will render the notifying bank liable if it is guilty of fraud or in conspiracy in the commission of fraud with the supplier of the material. That is a very important principle, because that falls under the exception and a very important aspect of letters of credit. This has not been asked as far as I know, and to my mind, I always include this in my lecture because of the possibility that it might be asked because of its importance. Distinguish a letter of credit from a trust receipt. A letter of credit is the credit accommodation in favor of an importer or a buyer, and a trust receipt agreement is a security for the repayment in a letter of credit. So a letter of credit is a contract under the Code of Commerce. What governs a letter of credit? So, in the following order: Code of Commerce, customs and practice usages generally accepted, and the civil code, in that order. And that also applies to all contracts still governed by the Code of Commerce, like charter party, loans on bottomry, loans on respondencia, loans on bottomry, that is on the security of the vessel, and loans on respondencia on the security of the cargo. And then on maritime commerce, you also apply the Code of Commerce, Customs and Practice and Tradition, and then the Civil Code in that order. When is a letter of credit perfected? There is a decided case, Bellman versus Central Bank. A letter of credit is perfected when the correspondent bank of the issuing bank pays the goods. That is the time when the letter of credit is perfected. But then, is that not a departure to the provision of or the policy under the Spanish Code of Commerce that time is always of the essence? Should it not be perfected when the bank agrees to issue? It is perfected because it is already demandable. But then we have a decision of the Supreme Court in Bellman versus CB, and the law is what the Supreme Court says it is. Now, whether the goods tally with the documents, that is not the responsibility of the correspondent bank who gets paid for the transaction, because the correspondent bank is concerned only with the validity of the documents. And so what are these documents? The invoice, the transaction, and the bill of lading, and depending on the agreement, whether it is free on board, whether it is COD, the correspondent receiving bank is concerned only with the regularity and genuineness and validity of the documents. Now, under Code of Commerce, the syllabus for every bar exam in commercial law includes the bulk size law. And you might be wondering, what is the relationship of the bulk size law with the Code of Commerce? It is understandable that a trust receipt under PD 115 is related to the Code of Commerce because a trust receipt is a security for a letter of credit, which is still governed by the Code of Commerce. But anyway, bulk size law is very important because it is closely interrelated and intertwined with the provision of the Corporation Code in case of sale, encumbrance, or assignment of all or substantially all of the business of the corporation, where the seller is a corporation, to be valid even after complying with the stockholders' resolution representing 2/3 of all the capital stock. If the bulk size law will not be complied with, then the sale by the corporation of all or substantially all of each assets would be null and void, because under Article 5 of the Civil Code, acts done in contravention of prohibitory and mandatory provisions of law are null and void, except when the law itself provides for their validity. What are the transactions covered by the bulk sales law? Sale of all or substantially all of the stock in trade. Just remember, stock in trade. All or substantially all. Or sale of all the business. The entire business, including the goodwill. And number 3, sale of all the furnitures and fixtures used in the business. Now, a case in point, which is an error committed by the Supreme Court, is the case involving a foundry shop that was sold lock, stock, and barrel, including the goodwill and all the furnitures and fixtures. And the ruling of the Court of Appeals is that it is not covered by the bulk sales law, because the bulk sales law covers only sale of all or substantially all of its wares, merchandise, and stock in trade. And the foundry business and the furnitures were not covered by the bulk sales law. That is a colossal error, because the bulk sales law would apply to 3 transactions, or where the subject matter of the sale, encumbrance, mortgage, or transfer, number 1, just remember, stock in trade. And then number 2, all the business together with its goodwill. And number 3, all the furnitures and fixtures used in the business. Any of the 3 would require compliance with the bulk sales law. And to be valid, there should be a written inventory of the assets to be sold, and a list under oath of all the creditors and the respective names and addresses of the creditors before consummating the sale. And upon acceptance of the process of the sale, there should be a distribution pro rata of the proceeds of the sale to the listed creditors. That is a mandatory requirement in case of sale of all or substantially all of the assets, or the business, or the furnitures and fixtures used in the business. 3 cases where the bulk sales law would apply. And the purpose is to prevent secret and fraudulent sale. And if the sale violates the trust receipt law, then any interested party may declare the sale null and void, may nullify the sale. So much with before I leave the Code of Commerce. In maritime commerce, the old Code of Commerce still apply. And the important principle in maritime commerce is the real and hypothecary nature of maritime transportation. The real and hypothecary nature of maritime transportation means that if the vessel sinks into the bottom of the ocean and the passengers die, all the cargoes are destroyed or damaged, the ship owner is relieved from any liability. The only exception is if the ship owner is negligent, and the negligence of the captain under the principle of respondeat superior is also the negligence of the ship owner. And that is really very material. Now, there was a very controversial, because it is a borderline case, that was asked in the bar on constructive total loss in the law on maritime insurance. The problem goes something like this. The ship sank into the bottom of the ocean. So it is to the mind of the insurer, it is a total loss. Now, constructive total loss is when 3/4 are lost, then recovery, rather compensation as a whole would be given by the insurer. But here, the case is the ship sunk into the bottom of the ocean. So, it's gone. And it is covered by insurance, so the insurer pays the full amount. The owner, the ship owner, assigned the salvage operation. Let us say that the value of the ship is 4 million. He sold his right for 1 million. And a salvage operation was undertaken, and the vessel was brought up, and by some more expenses, it was restored to its original condition. Question: may the insurer make a partial recovery or equivalent only to 1 million? Or this is related to an actual case, but anyway, we will discuss that when we go to transportation. See, I am posing a Makbar question, which is a cliffhanger. You just wait. What would be the answer when we come to transportation? Because after the Code of Commerce, so we have negotiable instruments, then insurance. The concept of insurance, it is that it is a risk distributing device, that the insurer will issue insurance policy, and in exchange to payment of premium, they will undertake to compensate the happening of a contingent event. Even a past event may be the subject of insurance if it is not yet known to the parties. In a leading decision, I think Chief Justice Davide, if I'm not mistaken, or was it another justice, who defined the synagmatic characteristic of insurance. What the hell is the meaning of sinaglamatic nature of insurance? I think it was defined in the dissenting opinion of Justice De Leon, if I'm not mistaken, because the majority decision was penned by Chief Justice Davide, reversing the first initial majority opinion. And I am referring to the Masagana Telemart case. Now, before I go to that, what are the requisites of a valid insurance? Foremost of them is payment of premium. And under Section 77 of the Insurance Code, notwithstanding any agreement to the contrary, the insurance policy shall not take effect except upon payment of premium, with the exception of health insurance, where there is a grace period. So that is the provision on Section 77. And these are the facts of the case. A building was covered by a fire insurance. Under the policy, the insured is given a grace period of 60 days from the lapse of the term for payment of the policy. So in the past, the policy would be paid within the grace period. Here is what happened. Before the payment of the policy, the building got gutted by fire, but within the grace period. So the insured did not notify the insurer, because the insurer might refuse the payment without telling that the building has been raised by fire. The insurer paid for the premium within the extended period. There is an amendment. I think that this was even introduced by Congressman Nani Perez of Batangas. An amendment to Section 77 of the Insurance Code that notwithstanding any agreement to the contrary, the policy shall not take effect until payment of premium, with the exception of health insurance policy with grace period. Oh, this is not a health insurance policy. Now, in the initial decision of the Supreme Court said, held in favor of the insurer. Section 77 is very clear. No insurance policy shall take effect without first payment of premium. And the dissenting opinion, I just do not recall who was the dissenter. Maybe it was Judge De Leon, who said that the payment of a premium is the lifeblood that will support the viability and existence of a viable insurance system. Because if premiums may be granted on credit, time will come that if the loan credits cannot be collected, the insurance industry will collapse for lack of funds with which to pay. Because the second requisite of insurance is that there is a common fund from which compensation may be taken, because without that, and that is the synigmatic characteristic as described by the dissenter in the Masagana Telemart case. On motion for reconsideration, penned by Chief Justice Davide, the Supreme Court allowed payment of under the insurance policy, compensation for loss by fire. Number one, the reason given is that the insurance policy is under estoppel. Why? It accepted the payment. Oh, not necessarily that. It is under estoppel by allowing loans for premium, that is payment within the extended period. In other words, the loan is granted for the period of the grace period granted within which to pay renewal. There is nothing more to renew because it has expired. But if that is allowed, then the insurer is bound. And related to that is estoppel. By allowing credit extension, the insurer cannot unjustly enrich itself at the expense of another. And next reason is the provision of the next section, section 28, where there is a recognition of payment of premium in the policy itself. That is another exception. But I think that the ruling is based mainly on estoppel and the practice in the past where payment on credit under the extension is allowed. But precisely that has been abandoned and repealed by the amendment to section 77, that is, notwithstanding any agreement to the contrary, no policy shall take effect except upon payment of the premium. And that is a very clear policy, and in the competing value of estoppel and a clear legislative intent, I think that the Masagana Telemart should be revisited, because the Supreme Court itself is ambivalent on the issue. And there is a provision on the jurisdiction, mandatory in nature, of the Supreme Court in bank, that where there are two conflicting decisions, then it is for the court in bank to reconcile, harmonize, and if necessary, reverse prior decisions that are ipso facto abandoned. And that is one of the grounds where you can ask for a second motion for reconsideration in a decision of an in-bank and ask for oral argument before the commission in bank in a decision of a division. And to me, it is an anomaly in the Supreme Court that it is the same division that will decide whether a motion for reconsideration would be elevated to the court in bank, and the decision is final, and there is no appeal to the in bank. Now, among the grounds where a second motion for reconsideration may be resorted to, but the remedy is file the second MR with the same division that rendered the adverse decision, and the decision is final. Another ground is the in-bank may give due course, or rather due course, or a second MR with motion for oral argument to refer to the in-bank may be based on the ground that the Supreme Court in-bank finds it that on the merit, the motion deserves to be entertained by the in-bank, but without sending it first to the in-bank, where the denial of the second motion and the motion to refer to the in-bank is finally killed in the same division, which has either reversed an existing ruling, which is for the in-bank, which is the in-bank only has the exclusive jurisdiction. And anyway, this is already outside commercial law, but then we will have a discussion on this in remedial law. What are the grounds for a motion for second reconsideration? And one ground is it should be for the Supreme Court in-bank to deal with where there is an allegation of graft and corruption in the division. But then it is the division that will decide whether to elevate to the in-bank or not. Is that not self-serving and anomalous and irregular, which is marks of conflict of interest? But anyway, we will go into that when we go to remedial law, and maybe incorporate a little bit on my suggested reforms to combat graft and corruption in the judiciary. Now, I am very elated that with the new judges, young, energetic, hardworking judges, in the courts where I have appeared, in the MTC and the RTC, judges are very industrious now and very straight and very competent. But anyway, let us continue with insurance. Another important principle or rule in insurance is with respect to suicide in relation to contestable clause. From the issuance of the insurance policy on life or its last reinstatement or renewal, within 2 years, the 2-year period is known as the contestable clause. You can contest the validity of the policy within 2 years. And related to this is the rule on suicide, where the suicide takes place after the lapse of the contestable period, after 2 years, then the cause of suicide is immaterial. Whether it is intentional or not, whether it is caused by insanity or not, suicide committed outside the contestable period of 2 years is compensable. Now, if committed within the contestable period of 2 years, then it depends on whether the one who committed suicide is insane or not. If he is insane, it is compensable. If he has a lucid mind, then it is not compensable. What do you understand by environmental insurance certificate, which is required in the construction of infrastructure of the government among contractors? Nako, mayayaman yung mga kontratista, the favored contractors, whatever government supply. But in the construction of infrastructure where there is a possibility of damage to the environment, the DENR requires the coverage known as mandatory insurance, mandatory environmental certificate. I do not have the time. I should be able to budget my time. Anyway, let us go to another special law. Commercial law. Transportation. A common carrier is engaged in the transport of passenger or goods by sea, air, or land for compensation and open to the public. The importance of knowing the difference between a common carrier and a private carrier is that a common carrier has the responsibility to the public such that in case of any injury to passenger or damage to goods, the common carrier is presumed negligent. You do not have to prove the negligence of the common carrier because it is presumed if it is a common carrier. And the defenses available is a fortuitous event without its contributory negligence. Now, in case of contributory negligence, then the amount of damage may be mitigated. Now, you will not forget, if you will compare a common carrier with a prostitute, it must be for compensation and open to the public. An example, without compensation, a boy, newspaper boy, who boarded the passenger bus without paying any compensation, got injured. Is he entitled to compensation? The answer is no, because there is no relationship, passenger common carrier relationship with him, because he did not pay the fare. So it must be for compensation. And maybe you will not forget if you compare it with a prostitute. if it is not for money or for a fee. If it is free, it is not prostitution. Now, many issues have arisen on payment of compensation. A mother carrying a child, is the death or injury of the child compensable? Yes, because the child is an adjunct of the mother. The mother pays the pair. I started my lecture under the Code of Commerce that maritime commerce is covered. The rule is if the damage is apparent to the cargo, a notice of claim must be made within 24 hours. May be made, I think, immediately, or if not apparent, within 24 hours from embarkation. Now, if it is a inter-ocean transportation, the Carriage of Goods by Sea Act is applicable, and it is the law of the destination that applies under the COGSA. And the prescriptive period under the COGSA is only 1 year. Is it necessary to file a notice of claim under the COGSA? No, as long as it is filed within 1 year. Now, Warsaw Convention in air transportation. The Warsaw Convention of 2019, to which the Philippines is a signatory, limits the liability that it has to be declared, and the corresponding fare or freight should be paid. Otherwise, it is limited only to what is stipulated in the bill of lading, or what is stipulated in the ticket. Now, does it limit the claims for damages for negligence or for discrimination or violation of constitutional rights? In Lopez versus Pan-Am, the claim for moral damages is not limited by the Warsaw Convention. The Civil Code provisions on damages, insulting the passenger or violating the contract of carriage with malice and bad faith, would be meted with corresponding damages under the Civil Code. Public Service Act. A franchise may be granted for business, let us say mass media. A franchise is needed, like the case of ABS-CBN, in order to engage in the business of mass media. But recently, in the case of online sabong, I smelled that there was an application for a franchise to do online sabong before Congress, and it was moving smoothly, and so I came up with my blog in the Facebook that if a franchise would be granted to a particular operator, that would be a violation of the Constitution, because online is not a public utility, and it is not even covered by the Public Service Act, where a certificate of public convenience is required to be obtained, as in the case of transportation. But online is not a public service. It is a money-making business, which is even, I would say, not in consonance with the traditional concept of sabong. And to grant online sabong to a particular franchise holder would be a violation of the Constitution, because sabong is supposed to be open to the public, and the business of sabong is not a public utility that can be granted with a franchise. And I even announced I'm going to attend any public hearing on the franchise application of any group who wants an exclusive franchise for sabong, and I will stand up. And some of my friends were asking me, are you not afraid? Of course I am not afraid. I will die anyway. I almost died of COVID. And heroes are made, not born. Made by circumstances to which vigilant and courageous stand is made, regardless of the dire consequences. According to the poem that I learned in high school. Oh, you may consider this as an intermission. In the broad field of battle, in the bivouac of life, be not like a dumb-driven cattle. Be a hero in this strife. And I'd rather give up my life for a noble goal. But anyway, that is only an intermission. So, transportation. Corporation law. Now, I think I have reached the 1/2 mark, but don't worry, we will finish. The most important thing that we will be discussing after corporation law and intellectual property would be the special law on Financial Rehabilitation and Insolvency Act of year 2010. Now, this is my practice in the financial jungle in Makati, and I think that it's only my office that has specialized in this practice. So many borrowers come to us, and I have an outline of the PRIA that I will be discussing with you. Now, let me just pause for 3 minutes, and then we will continue. I'm going to finish the entire subject matter. Although I cannot deal with each and every provision, I am just concentrating on what might be asked. I have a glass of water from my daughter. Maybe a 1 minute recess would do. So, all right, let us continue. Maybe my listeners are already tired or sleepy. So, when in the course of my lecture, and by the way, I am used to lecturing whole day. In the morning from 8 to 12, commercial law review, and in the afternoon from 1 to 6, either remedial law or criminal law review at the UE during the time of Dean Amado Valdez. So let me go directly to corporate rehabilitation and insolvency. The FRIA, Financial Rehabilitation and Insolvency Law, amended and superseded the insolvency law. This has adopted the law on financial rehabilitation in the United States, where distressed corporations may file for rehabilitation, suspension of payments, or relief from the pressure of due and demandable debts. Under the FRIA, a corporation which has or a partnership or any individual may file for petition for rehabilitation, and the effect of filing this petition is that within 5 days, the commercial court will decide whether to dismiss the petition for lack of proper form or substance, or to issue a stay order. Now, the formal requirements are very voluminous, because you have to put as annex in a petition for rehabilitation an inventory of all the assets, and then the audited financial statements in the last 3 years, and then a list of creditors, and the loan documents, and the most important annex of all is the rehabilitation plan. How you propose to offer to the creditors a viable rehabilitation plan, and the plan should be there, complete with cash flow and the possibility of continuing in business, because rehabilitation must have a viable plan to continue with the business, free from the hampering effect of collection suits from the creditors. The important thing to remember here is the principle of equality in equity. That is a very important concept, equality in equity in rehabilitation. And that is, the meaning of that simply is that the secured creditors stand on equal footing during the period of rehabilitation. Now, is not a secured creditor entitled to the benefit of his bargain, that he is entitled to the collateral as a security for the repayment of a debt, compared to a clean, unsecured creditor. But that is the principle. During rehabilitation, a secured creditor cannot foreclose. And so in most of the time, when a distressed corporation is suffering from liquidity and is being harassed by suits left and right, the remedy is to file for a rehabilitation proceeding, and where a stay order within 5 days if the petition is in proper form and substance, meaning all the annexes are in place and in substance it is compliant with the Financial Rehabilitation and Insolvency Act. Number one, that the applicant is not insolvent. Rather, the applicant, I repeat, has more assets than liabilities under the PRIA. Because before the PRIA, under existing jurisprudence and rules before the SEC, rules applicable when rehabilitation was still being conducted in the Securities and Exchange Commission, there is a distinction between extraordinary suspension of payments, and that is where there are less assets than liabilities, so the petitioner is insolvent, but there is a likelihood of rehabilitation under the rehabilitation plan. And ordinary suspension of payments where there are more assets and liabilities, meaning the assets can cover the liability. Now, insolvency has two meanings, and that has been adopted in our jurisdiction. The meaning of insolvency in the United States. The first kind of insolvency is the balance sheet insolvency, where the assets are less than the liability. The petitioner is insolvent. And number two, where there are more assets than liabilities, but the petitioner cannot pay the obligations as they mature, and that is being insolvent in the equity sense. And these two tests have been embraced and incorporated in our jurisdiction under the new BSP law, whereas before bankruptcy was defined only under the balance sheet test. Now insolvency includes in the definition of insolvency under the new Central Bank Act, Bangko Sentral ng Pilipinas Act. The inability to pay the obligations as they mature is a ground to uh, put a bank under surveillance. But anyway, this insolvency in the equity sense has been incorporated in our banking laws as well as in the PRIA. But then it is an issue whether a bankrupt corporation in the equity sense may be granted, and I think that the answer should be in the positive, because precisely that is the purpose of financial rehabilitation. But since an inventory of assets are required to be submitted, and a list of creditors, including the corresponding documents, are required to be submitted as annex, then it is doubtful whether a company that is insolvent in the balance sheet test may still be the subject of rehabilitation. But as I said, we are both a court of law and equity. And under Book 5 of the Civil Code, we have accepted the generally accepted principles in common law countries. So anything that would result in inequity may be corrected. But let me proceed. Another benefit for having a stay order, number one, all the cases pending in other courts shall be hailed into the insolvency court, not insolvency, into the rehabilitation court. But the rehabilitation court has the discretion where technical know-how is involved. For example, it's a labor case. Then a clearance may be given by the rehabilitation court to allow the Department of Labor to proceed with the case. So it is a matter that consent to proceed must be obtained from the rehabilitation court. Otherwise, it is suspended. And when is the suspension lifted? The suspension would be lifted if the rehabilitation plan fails, if the rehabilitation proceeding fails. It is dismissed for inability to comply with the plan. Although there is a grace period, an extension may be requested for the petitioner to comply with the repayment plan. And if the rehabilitation plan is approved, then the stay order goes together with the rehabilitation plan, and from up to a period of 15 days, the suspension of payments may run under installment plans that may be paid to the secured and unsecured creditors. Now, the secured creditors under the equality in equity, as long as the secured creditor would receive under the rehabilitation plan an amount better than what he will receive in case of liquidation and sale within 3 months, then his property right is not violated because the rehabilitation legislation is a police exercise of the police power for the benefit of the greater number of people. So a rehabilitation plan that gives a haircut, that diminishes the amount, is still valid, and under the principle of cram down. Another very important principle in rehabilitation plan. A secured creditor, as long as he will receive more under the rehabilitation plan than in straight liquidation to be conducted within 3 months, then his right is not violated. But how about his vested right? He is entitled to the benefit of his bargain. In the competing values between the police power and property rights, the police power ranks higher in the constellation of constitutional values among competing values and interests. So that is the benefit of cram down. An important benefit of being under rehabilitation is the company or entity under rehabilitation is exempt from the payment of all national and local taxes during rehabilitation. And in fact, even taxes are among the claims that might be subjected to repayment plan under the rehabilitation proceeding. I have an interesting case that I handled. I will not mention the name, but it is a steel company engaged in manufacturing steel products. The monthly customs duties being paid by my client who was under rehabilitation is 300 million a month. Can you imagine 300 million from the time the stay order against collection of taxes is issued, and that is within 5 days from the filing of the petition for rehabilitation. Now, the venue in rehabilitation proceeding is jurisdictional. It is in the principal place of business of the applicant or the petitioner, and that is jurisdictional. If you file it in another venue, that will be dismissed automatically outright for improper venue. From the time the petition is filed, the judge will decide whether the petition is in proper form and substance. In proper form, whether all the annexes are in place, and in substance, whether there is a likelihood of rehabilitation. Matter of substance, considering the cash flow and the financial position or predicament of the applicant. And that will continue until the approval, until the dismissal of the rehabilitation plan, or if the rehabilitation plan is approved, then the suspension of payments will be included in the repayment plan, which might be up to 15 years, where the secured creditors may be given a haircut or a cram down. Can you imagine how much national and local taxes involved? That includes payment of real estate taxes and all the national taxes. That is the provision in the PRIA. Now, I handled a case where jurisdiction was at issue because under the charter of the, or there is a law on jurisdiction with respect to tax cases. So, if it is an assessment of the Bureau of Internal Revenue, then the appeal is to the Court of Tax Appeal. Now, if it is under the Bureau of Customs, then the decision of the Customs Commissioner is appealable to the Court of Tax Appeal. And the provision says that taxes under the National Internal Revenue Code falls under the jurisdiction of the Court of Tax Appeals. And same thing, under decisions of the Collector of Custom is under the Tariff and Customs Code is appealable to the Court of Tax Appeal. But this is a tax, an exemption provided by the PRIA. So, under the rule of ejus dem ineris, since it is a waiver of all national taxes, which includes the customs taxes, then it is outside the jurisdiction of the Court of Tax Appeals. And my contention is that it is under the jurisdiction of the PRIA because it is an exemption granted by the PRIA. And can you imagine? Monthly taxes, minimum of 300 million. Now, the venue under the PRIA is the RTC, the commercial court designated by the Supreme Court as special commercial court. So I filed a petition for injunction against the Bureau of Customs from collecting and imposing 300 million customs duties on the steel imported by my client. And I filed it in the regional trial court where the principal place of business of the petitioner is located. I got an injunction. To my mind, it's very clear. Now, the Bureau of Customs is trying to collect taxes. What is the remedy? If the Bureau of Customs is trying to collect taxes, they can appeal if they wish, because we do not want to pay. They can appeal to the Court of Tax Appeals if they wish, but it would not fall under the jurisdiction of the Court of Tax Appeal because it is a waiver of all national taxes under the Financial Rehabilitation and Insolvency Act, and the jurisdiction falls within the exclusive authority of the regional trial court designated by the Supreme Court as a special commercial court. And so what I did was to appeal the order of the rather to appeal the resolution of the Bureau of Customs I appealed it, imposing taxes and disregarding the waiver under the PREA of all national taxes. So I appealed it to the Department of Finance. Denied. I appealed it to the Office of the President. But in the meantime, I have a TRO in the Regional Trial Court. The problem is something happened in the lower court. The decision favorable to my client was reversed by the Regional Trial Court. You see, before the jurisprudence was laid down that interlocutory order should be raised under Rule 65 within 60 days. Otherwise, it has to wait to be included in the appeal in the main case. There was no such ruling yet at that time. So, an interlocutory order where proceedings are still to be held may be raised, and it is not even subject to the prohibition against second motion for reconsideration. Na disgrasya yung aming rehabilitation sa baba. I will not speculate how it happened. But anyway, we were in the Supreme Court where I was the counsel of the petitioner, and I did a good job getting a TRO or an injunction against imposition of taxes, 300 million a month for several months or even years. When a compromise was reached in the case that I filed in the Supreme Court, I was terminated. I did not know I was substituted, and I did not even know that there was already a compromise with the big creditor, BDO, without even telling me. That's why I was so mad with the underwriter who arranged it. I even threatened to go to the International Monetary Fund to complain against their unethical practice. But anyway, I changed my mind because I do not want to be that controversial. So, my client, I could not even see anymore. After I was requested to withdraw my appearance in the Supreme Court because they already settled amicably with BDO. But when my appearance was similarly withdrawn in the RTC, they lost the case. They got a reversal, and I think they are being made to pay the waived customs duties. But anyway, I am out of the case. So let me see, what else do we have? Corporation law. The important concept in corporation law, no, the definition, it is an artificial being with the properties, right of succession, and rights granted by law or implied from or implied. A corporation has a personality separate and distinct from each stockholder, and a stockholder or a director is generally not liable for acts for corporate acts with a certain exception. If, for example, the officer or the stockholder or director has executed a joint and several undertaking for the loans or obligations, then he is liable. Or if he is guilty of a criminal act on behalf of the corporation, or where the directors have acted beyond the scope of their authority. And that is the same general rule on agency, that an agent who exceeded the limit of his authority is personally liable. What are the duties of a director? A director has the duty of loyalty to the corporation, and the corresponding principle is the doctrine of corporate opportunity, that a director cannot appropriate a business opportunity, that property belongs to the corporation. Under the best judgment rule, as long as a corporation, a director or an officer is not negligent, he is not liable for his corporate acts done in good faith under the best judgment rule. Derivative suit. A stockholder of record has the right to file a derivative suit on behalf of the corporation. But one requirement is that he must exhaust intra-corporate remedies. That is, make a demand with the management and board of directors. And the supposed damage or injury caused by any transaction to the corporation must have taken place at the time that he is already a stockholder. Now, I have a question. If I were the bar examiner, I will ask this: preemptive rights. The preemptive right means that a stockholder, when there is an increase in the authorized capital stock, may subscribe pro rata to maintain his pro rata share in the corporation. He has the right to subscribe pro rata to the increase. Question: if a stockholder is delinquent, there is a call to pay unpaid subscription, he cannot pay. But it is not yet put on auction, because it will be sold if he does not pay. He is just delinquent by a demand for payment, and he has not yet paid. Question: is a delinquent shareholder entitled to preemptive rights? Now, a delinquent stockholder, if he has the right to vote, cannot vote because he is delinquent. But with respect to preemptive rights, is he entitled to preemptive right? there is no answer in the corporation code. This has not been taken in any decision. But I would answer it, yes. And what is my reason? Because when his shares are auctioned off, included in the sale of his delinquent shares are his preemptive rights. Ergo, a delinquent shareholder is entitled to preemptive rights. And the buyer in the auction would be entitled to preemptive rights. But then, as against that, arguing against that, a delinquent stockholder cannot vote, has no right to vote. Piercing the veil of corporate entity. Usually the questions asked deal with piercing the veil. And you know the three grounds of piercing the veil. Anyway, I think everybody knows that already. So let us proceed. It is 11:10. Intellectual property. We are a member of the World Trade Organization, WTO. We acceded or become a member to this TRIPS agreement, trade-related aspect of intellectual property, in the Marrakesh Treaty. The principle is globalization, equality of right among nationals of member countries to the WTO. And this is the reason why previous administrations were in a hurry to amend the economic provisions of the Constitution so that we can be in tune with globalization. Under the Philippine Constitution, it is a declared national policy that the state encourages the development of a national economy in the hands of Filipinos. And there are partially nationalized economic activities, like in transportation as common carrier, mining, allowing the entry of 40% foreign capital in a joint venture corporation established domestically or in the Philippines, where 60% is owned by Filipinos. Now, in the computation of what is 60% Filipino, we apply the grandfather rule. Now, if the stockholder of a joint venture 60-40 company to be engaged in the exploitation, development, and utilization of natural resources, the 60% should be Filipino ownership should be reckoned under the grandfather rule, because under the Foreign Investment Act, a 60-40 corporation may be a stockholder in another 60-40 corporation that will be engaged in the exploitation, utilization, and development of natural resources. Now, so the grandfather, under the grandfather rule, the composition of the 60-40 or whatever composition should we should compute the Filipino component, and that should be taken into account to compute whether the 60-40 engaged in the exploration, development, and utilization of mineral resources complies with the constitutional requirement. And again, I go back to Gamboa, the case of Gamboa versus Tebes, that the computation should be 60% Filipino, and also only 40% will be allowed to foreigners. Whereas before, the computation is reckoned with only on the voting shares, and sky is the limit on the preferred shares. That has been done away with in the case of Gamboa versus Tebes, which has been asked in 3 successive bar examinations, were asked in different subjects: constitutional law, commercial law, 3 times successively under different angles. Essentially, going back to derivative suit, essentially it is a suit against management doing an illegal act injurious or damaging to the corporation, and one requirement is intra-corporate exhaustion of intra-corporate controversy. The award of attorney's fees is in favor of the corporation, not in favor of the stockholder filing derivative suit, and the plaintiff is the corporation. Let us go to the more interesting aspect of Securities Regulation Code. This, the precursor of this is the Blue Sky Law. The Securities Regulation Code prohibits investment, any speculative investment is governed by the Securities Regulation Code. For example, the foreign investments solicited by ABS-CBN from foreigners, these are listed in the stock exchange with the Securities and Exchange Commission. Now, what scheme are prohibited by the Securities Regulation Code? The pyramiding scheme. The recent fiasco where investors, which started in Surigao, were promised with a return of 10% interest per month, and they could do this by pyramiding, because by accepting money, they promise to give monthly 10% dividends, and initially, while the number of investors have not been exhausted, then investments from new investors will be used to pay 10% interest. And so they started that in Surigao. Then later on, they went to Butuan City. But when they went to Cebu, a complaint was filed with the Securities and Exchange Commission. And so the pastor who was behind this, I do not know if he was arrested, because this is a speculative investment that is prohibited by law. Now, any investment contracts, whether by stock subscription with a corporation or accepting money from the public by way of investment, under the definition of what is a security, under the Securities Regulation Code, any kind of speculative investment, while it is not prohibited, must be registered with the Securities and Exchange Commission and listed in the stock exchange so that it may be regulated to prevent fraud on the public. Now, if the investment is limited only to not more than 20 people, then there is no need to register with the Register of Deeds. It is securities that are speculative and that are offered to the public. Now, if it is a donation without corresponding dividends, then it is not prohibited. But the problem with that scam that started in Surigao is that the pastor is receiving donation, kuno, but with a promise of 10% dividends monthly. And at the start, people who started making the investment made money. But then later on, it collapsed. It is bound to collapse because the pyramid, when the investor reaches the saturation point, there will be no more source of repayment. Now, how about Pastor Kibuloy? Kibuloy is not promising anything. It's not a scam because donation for religious purpose is not prohibited. Now, this is a scam with another pastor in Surigao, because in the guise of a donation, he accepted investments, money for investments, and that is covered by the Securities Regulation Code. Now, let us connect that to online sabong. There was a group, I think, oh, never mind, I will not mention the name. Recently, collecting 5 million subscription to a company that will operate online, and 1 million to members, about 3,000 members, 1 million each. That is covered by the Securities Regulation Code. If that is not registered, because that is an investment, any kind of investment with more than 20 people is governed by the Securities Regulation Code. Now, they are lucky if nobody is questioning it, because if there is no complainant, then there is no case. If there is nobody defrauded, then there is no case. But technically, anything, any investment scheme where money is collected from the public for a promise of big dividends, that is a security by definition of the Securities Regulation Code, and therefore must be approved by the SEC and must be listed in the stock exchange. Now, my suggestion for a new group that would like to engage in online, just have the capital contributed by not more than 20 stockholders with 15 members or directors not exceeding 15, and then make an arrangement with breeders directly with the breeders without asking any membership fee from them, and under an arrangement that they will provide the entries and under the direct benefit without passing through a middleman, so that there will be continuous sultada every day and give the full benefits to the breeders participants without passing through middleman, for the benefit of the breeders participants. And that will not be covered by the Securities Regulation Code, just like contribution to Kibuloy, because he is not promising anything, and the deal with the breeders for providing the entries is not an investment contract, but an ordinary contract. It is not a security, but a direct agreement with the breeders without accepting anything, any membership from them. And better still, I have in mind a cooperative breeders association with the incentives and benefits, even tax exempt and counterpart funds provided by the government under the cooperative law. And that is what I am trying to organize in San Jose, Batangas, because if this will be successful, we can even own a feed mill, we can even own a store, we can loan funds to member breeders, and eventually maybe we can even own a cockpit and engage in online for our own benefit. Because if a cooperative will be organized, then there is no need to register the members, and we can in the articles and bylaws we can put up the rules and regulations. But anyway, that is only an idea. Now, under intellectual property, this covers patent, trademark, and copyright. There is a distinction when it comes to trademark, a distinction between unfair competition and violation of trademark. Violation in unfair competition, there is no need for registration for there to be violation of unfair competition. Whereas in trademark infringement, the trademark must be registered. Is it possible to have a trademark infringement without unfair competition? The answer is yes. If the infringer discloses his brand, which is similar, and he is not passing off his brand to be the product of the registered trademark holder. A little complicated, but that was the ruling in one case, that he is not passing off the products, but there is infringement because he copied the title, he copied the brand, and there are two tests. The holistic test, to test now a copyright is perfected even without registration. So when we write a book, we register it with the National Library. But that's not even required for an intellectual creation be protected by copyright. Excuse me a minute. Ding, ding, ding. Do not leave me. Bigyan mo ng tubig.
Naka-online ka pa, Daddy.
Oo nga eh. So while I'm waiting for my water intermission, joke. One time, merong gustong mag-apply na maid.
Okay na.
Ang sabi nung nag-a-apply na maid, andun yung misis, andun, napagkamalan niya na katulong. Sabi Day, tawagan mo si ma'am, mag-a-apply ako ng maid. Oh, bakit ka naman mag-a-apply na maid? Gusto ko hong lumipat dahil dyan lang ho ako sa kabilang bahay, pero gusto ko hong lumipat. Ayaw ko na doon sa amo ko. Ngayon, dumating ngayon yung husband. Sabi nung katulong, ay, si attorney pala, dito nakatira. Oh, bakit? Bakit mo kilala si attorney? Dahil po malimit po yan sa bahay namin. Ako po maid ng byuda. Diyan lang ako sa kabila. Malimit ho kung nakikita yan. Ganon ha. Bakit naman gusto mong lumipat? Kasi ho, yung aking amo, byuda, ayaw ko na ho. Gusto ko lumipat. Bakit naman na byuda? Kasi ganito ho yun. Ako ho, humihingi ng uminto sa kanya. sinabi sa akin, bigyan mo ako ng rason, bakit kita bibigyan ng aumento? Ako raw ho magaling magluto kaysa inyo. Sino may sabi niyan? Si Sir? Hindi. Opo. Ano pa? Ako raw ho magaling sa kama kaysa inyo. Sino may sabi niyan? Si Sir? Hindi po. Sino? Yung pong driver natin. Gayon, sabi, huwag kang maingay, bibigyan kita ng raise. Tahimik ka. Yun daw, sabi niya, yung husband daw, nakikinig, biglang inatake, namatay. Yun ang pangyayari, kaya naging byuda. Pagkatapos, nakikita mo si Sir sa inyong bahay. Ano namang ginagawa? Wala ho naman. Bibisita lang. Sige na, tawagin mo na si ma'am at kakausapin ko. Mag-a-apply akong maid. Yun. Sabi niya, mabuti pa, umalis ka na dahil ako ang sinasabi mong ma'am ay ako. Joke only. Hindi naman siguro totoo yun. Kapag ka po ako nagle-lecture, kung minsan nga maghapon, simula alas 8 hanggang alas 12 at alauna hanggang alas 6 sa mga review classes at mga seminar, hinahaluan ko ng mga jokes pagka nakakatulog na ang mga nakikinig. Ngayon sa Old Code of Commerce, ito namang mga iba mga corporation law, ito tinitake up naman ng inyong lecturer. Pero itong aking dinidiscuss ngayon, ito ang malimit itanong. And in relation to the Code of Commerce, ito palagi ang malimit na natatanong. Almost every 3 years or every 5 years. Ganito, who are merchants? Marami naman po na decided cases dyan. Merchants are habitually engaged in commerce. So, in relation to the definition of doing business under the Foreign Investment Act, it is related to the definition of who is a merchant. A merchant is a person habitually engaged in commerce. And correlating that with the Foreign Investment Act, doing business in the Philippines. If there is an intent to engage in commerce habitually, as for example, opening a store and an advertisement is already placed, that is already engaging in business, and that is already doing business. In one case, announcing in the Facebook that he is opening a store, that is already equivalent to doing business in the Philippines. Now, with respect to a foreign entity, a foreign entity may engage in business in the Philippines by registering with the Securities and Exchange Commission and appointing a authorized representative, where a foreign corporation has organized a business office in the Philippines. It is deemed doing business in the Philippines. And the distinction is this: a corporation doing business in the Philippines without a license can be sued but cannot sue. A foreign corporation doing only an isolated transaction, selling a product without a distributorship agreement, just not habitually but on an isolated occasion, cannot be sued in the Philippines. That is the distinction, and that is the importance of knowing whether a foreign corporation is doing business or not. And there are many borderline issues on doing business in the Philippines. And this is with respect to distributorship agreement, where an importer occasionally buys product from an exporter, a supplier, under PO. And it is a direct sale. The manufacturer does not retain ownership or control. The manufacturer cannot be sued in the Philippines. You can only sue the one selling. However, where the manufacturer puts up a repair shop in the Philippines, that is considered doing business in the Philippines. But if it is a direct sale, a simple importation, you cannot sue the exporter. In one borderline case that was asked in the bar, every 6 months, the computer is updated, and the distributor in the Philippines will return unsold computer, and the price is fixed by the exporter. The Supreme Court concluded that is doing business in the Philippines, as compared to a straight purchase and sale agreement, where the employer has nothing to do with ownership, with pricing, and the agreement of being able to return unsold goods was construed to be a consignment agreement, and in a consignment agreement, ownership is maintained. Now, you read the Foreign Investment Act on what constitutes doing business in the Philippines, because that would determine whether the foreign corporation may be sued, or if it is doing business in the Philippines without a license, then it cannot sue in Philippine courts. A question also in mercantile law, commercial law, which is provided or referred to in the civil code, but definitely it has a mercantile law flavor, and that is payment by post-dated check. Under the civil code, payment by check produces the effect of payment when the check is encashed. Question: is the acceptance of payment by check effective payment subject to the resolutory condition that when it bounces, then the payment is cancelled? Or is it subject to the suspensive condition of payment that payment shall become effective when encashed? Explain your reason. Now, let us connect that with insurance. Notwithstanding any agreement to the contrary, under Section 77 of the Insurance Code, no policy shall take effect until the payment of premium. A premium was paid by a post-dated check. Before the maturity and encashment of the check, the risk insured against, let us say it is fire insurance. The building is gutted by fire. Can the insurer collect? Well, under the resolution on reconsideration in Masagana Telemart, the insurer, or rather the insured, may collect, because this is a case of estoppel. The check was accepted as payment, and under Section 78, where the receipt of the premium is indicated in the policy, or where the receipt is acknowledged in writing, then the insurance policy is valid. And that will also fall under the case that there is a credit extension and there is what you call estoppel. Now there is I have a dispute with other authors. Now there are very few reviewers in mercantile law. Now a very good reviewer in mercantile law and in taxation is Judge Di Maampaw, or now Justice of the Supreme Court, promoted from the Court of Appeals to the Supreme Court. He's a very good lecturer on mercantile law, and we have Dean Cesar Villanueva. And then there is a small pre-week reviewer which has a different answer. And the answer is payment by check would not enable the insured to collect because of the specific provision of Section 77. And I disagree by citing the Masagana Telemart. I do not recall anymore that book, but I disagreed with the conclusion there that where post-dated checks were paid, because whether it is a resolutory condition or a payment subject to resolutory condition, or it is subject to a suspensive condition, in the meantime, under the provision of the express provision of the Civil Code, you cannot sue a person who paid you a post-dated check, because the obligation is not yet due. It is due at the time of the maturity of the check, and you can sue him only if the check bounces. Whether it is suspensive or resolutory, to my simple mind, that is irrelevant. What are the principal characteristics of commercial law? They do not ask questions anymore, define commercial law. But if you are asked to define, it is that branch of private substantive law that governs the rights, obligations, and relations of persons engaged in trade when the business traffic is within the country, and commerce which covers the intercourse with foreign states. Universal or international? It exists in every civilized country of the world, and trade and commerce usually are governed by international law. For example, arbitration, because principles in commercial law are universally accepted. So, first characteristic, universal or international. Progressive, because it is abreast of contemporary developments. Equitable, it involves a fair exchange of values. So when you say equitable, it is reasonable, it is value for value. And again, let us connect that with taxation. The taxation must be equitable, meaning that it should be assessed according to the revenue generated, not a flat revenue that PAGCOR is collecting. Because you cannot collect a tax on revenue that has not been earned, or revenue which the taxpayer fails to earn. That is the meaning of equitable, meaning reasonable, fair. That is the meaning of equitable, not unjust. Constitutional provision on commerce. We have a provision on national economy and patrimony, and the declaration of principles and state policies, that we shall develop a national economy in the hands of Filipinos. And there is a Filipino first policy that Filipino suppliers shall have priority in the supply of materials to the government. And there is even a law known as the plug law. But that is also provided in the declaration of policy under the Constitution. Now, are the nationalistic provisions of the Constitution discriminatory to nationals who are members of the WTO? Are we not in violation? Only Filipinos can engage in inter-island shipping. Only Filipinos can engage in education. Only Filipinos can operate schools or can operate or engage in media. And the principle in the Marrakech Treaty, whereby we acceded membership to the World Trade Organization, is non-discrimination, equality of treatment among members of among nationals of the members of the WTO. In one case, case of Tanyada, the Supreme Court held that there is no violation on principle of globalization and equality in treatment. Because according to the Supreme Court, what is prohibited under the Constitution is unfair competition. And a contrario, fair competition is allowed. But then the principle of equality in treatment, reciprocity. For example, we can own land in the US. We can own land in other countries in Europe. But foreigners cannot own land in the Philippines. The only way foreign nationals may own land in the Philippines is through a 60-40 domestic corporation or with respect to balikbayan going home, a former Filipino who is a foreign citizen may own land 1/2 hectare urban or industrial residential, 5,000 square meters, or 3 hectares rural. That's the only. And also by inheritance. If a foreigner inherits a property, then that is allowed as an exception to reserve ownership strictly to Filipinos. I have, by my clock, 4 minutes. My daughter and I have agreed that that the entire outline, at least we will start with political law and hopefully mercantile law, commercial law, and criminal law to be available in print in time for the pre-week, and that is next month. We will just print our outline of the important principles. Now, one of you who is my student in University of Manila is a member of the online school. They you can copy this. He has a copy. I gave him a free copy of this. His name is James Glota. Study guide for the bar series, mercantile law. by Dean Arturo M.D. Castro. You see, it's this thick. And I cannot read all this. I just selected the controversial ones that have been asked or I anticipate to ask in the bar. Now, I have 3 minutes. I just would like to announce that yesterday, for those of my relatives in Bukal, Batangas City, I brought an oxygen tank, a big one, with 16 pounds oxygen. I was unable to deliver it to the barangay captain in Bukal, Batangas City because I was busy in the farm, and I had to come back yesterday preparatory to this online. I left the oxygen tank with regulator in my farm in Sitio Antipolo, Dagatan, San Jose, Batangas. For those of you, my relatives who are listening to me, you can send the barangay captain to pick up the oxygen tank. I was able to deliver to my barangay in Taisan the other oxygen tank. Now, I asked the barangay captain of Don Luis, and he said he already has one. So, a relative is asking for oxygen tank for barangay Lapu-Lapu. I'll see if I can get one for them. I have relatives on the Makalintal side in that barangay, which is adjacent to Barangay Aya, where I also have agricultural properties. So it's 12 o'clock. We Sabongeros has I have something in my Facebook, the Mad Science group. One of them posted picking up my suggestion to democratize the game of sabong during the pandemic, and that is to allow every barangay to have barangay cockpit instead of tupada, to democratize and equalize the opportunity to enjoy this game of 1,000,000 thrills, enjoyed equally by common men and kings. But anyway, after the pandemic, hopefully, the traditional cockfight will be held in licensed cockpit if the health protocols would not be necessary anymore of social distancing. So, thank you for listening to me. I will see you again next time.